Good day, I am John Paul Meneses and I will discuss Title 13 Special Corporations, Chapter 3 One Person Corporation, Section 115 to 118. Section 115 Applicability of Provisions to One Person Corporations. The provisions of this title shall primarily apply to the one person corporation. The other provisions of this code apply suppletorily except as otherwise provided in this title. Since the one-person corporation is classified as a special corporation, it is primarily governed by the provisions of the Revised Penal Code of the Philippines Title 13. This is because the one-person corporation is a stock corporation except there is only one stockholder. Section 16. One-person corporation. The Section 16 defines one-person corporation as a corporation with a single stockholder, provided that the only natural person, trust, or an estate may form a one-person corporation, where in case of a natural person, incorporator must be of a legal age. So who are not allowed to form a one-person corporation? Number 1. Banks and quasi-banks. Number 2. Pre-need. Number 3. Trust. Number 4. Insurance. Number 5. Public and publicly listed companies. And number 6. Non-chartered, government-owned and controlled corporation. Take note that a natural person who is licensed to exercise a profession may not organize a one-person corporation for a purpose of exercising such profession. Section 117. Minimum capital stock not required for one-person corporation. A one-person corporation shall not be required to have a minimum authorized capital stock except as otherwise provided by a special law. Section 118. Articles of Incorporation. A one-person corporation shall file its articles of corporation in accordance with the requirements of Section 13 and 14 of the Revised Corporation Code of the Philippines. It shall likewise substantially contain the following. A. If the single stockholder is a trust or an estate, the name, nationality, and residence of the trustee, administrator, executor, guardian conservator, custodian, or other person exercising fiduciary duties together with the proof of such authority to act on behalf of the trust or estate. And B. Name, nationality, residence of the nominee and alternate nominee, and the extent, coverage, and limitation of the authority. So that's all for my part for Chapter 3, One-Person Corporation, Section 115 and 118.
Good day everyone, I am Laris Recto, the reporter for sections 119 to 123. So first, let's start in sections 119 of the Revised Corporation Code under the one-person corporations. So in these sections, it tells about the bylaws of one-person corporations. Bylaws is one of the advantage of one-person corporations over other corporations because in one-person corporations, they are never required to pass or to file bylaws. Because other corporations required to pass bylaws together with articles of incorporations. But here, in one-person corporations, SEC don't require them to pass the bylaws, but they need to pass articles of incorporations. So, kailangan ng one-person corporations na ipasa lang or isubmit lang yung articles of incorporations, hindi na yung bylaws. Hindi kagaya sa ibang corporations na kailangan nilang isubmit yung bylaws together with their articles of incorporations. So now let's proceed to sections 120. So in these sections, it tells about the display of a corporate name. So, corporations need to have their corporate name na hindi pa nakaregister or hindi pa nagagamit ng ibang corporations. Because when you submit the corporate name na nakaregister na, ay hindi na siya tatanggapin ng SEC or mabovoid na yung corporate name mo. So you need to think unique corporate name and submit it again to SEC. And in OPC, the corporate name shall indicate the letters OPC, which stands for one-person corporations, and you may indicate it either below or at the end of the corporate name. So, for example, the first one-person corporations here in the Philippines, which is the Smart Transportations and Solutions OPC. So, you may see na yung nilagay nila yung OPC sa dulo ng kanilang corporate name. So, now we're in sections 121. So, which is a single stockholder as director and president. So, in one-person corporations is a corporations. So, a one-person corporations is a corporations with a single stockholder. So, that single stockholder shall be the sole director and the president of the corporations. So, in section 121 ay sinasabi na sa OPC or sa one-person corporations, kung sino yung single stockholder, ay siya na rin yung director and president ng isang corporations. So, for example, I am the single stockholders of an OPC corporations or a one-person corporations. So, ako na din yung president and the sole director of that OPC or of that corporations. So now let's proceed to the next sections, which is sections 122. So in these sections, it tells about the treasurer, corporate secretary, and other officer. So within 15 days of the issuance of a certificate of incorporations, the one-person corporations shall appoint a treasurer, corporate secretary, and other officer. And after appointed, they need to notify the SEC or the Security Exchange Commissions within 5 days from the appointment. So, pag yung na-appoint ng one-person corporations na treasurer, corporate secretary, and other officer, ay kailangan nilang i-notify si SEC 5 days from the day of the appointment. So, remember that the single stockholder cannot appoint as a corporate secretary, but they can assume the role of treasurer of the corporations. If the single stockholder assumes the positions of being a treasurer of a corporations, he or she shall give a bond to the commissions or in the Security Exchange Commissions in such sum as may be required. So that single stockholder, which is also the treasurer of the corporations, shall undertake in writing faithfully administer OPC funds that he or she receive as a treasurer of the corporations. So now we're in the next sections, which is the sections 123. So in these sections, it tells about the special functions of a corporate secretary. So it is an additions functions that designated for one-person corporations, but it is under the corporate secretary. So these special functions is for corporate secretary. So the first special functions for a secretary is to be responsible for all the maintaining the minutes, books, and records of the corporations. As a secretary, you are responsible to maintain or to keep safe all the informations and records of the corporations because all the informations na nasa iyo is nandun yung mga confidential information. So, kailangan ingatan mo siya and para hindi siya mawala or mapunta kung kani-kanino. So next functions is to notify all the nominee and alternate nominee for the death or incapacity of a single stockholder. So, ikaw as a secretary, as a corporate secretary, ikaw din yung magna-notify sa mga nominee and alternate nominee kapag namatay or na aksidente yung single stockholder. So, dapat i-notify mo din sila not later than 5 days of the occurrence. Dahil nga, as a secretary ka, so dapat maging responsible ka na i-notify sila para alam nila yung mga nangyayari sa single stockholder. And the third functions is to notify the commissions or the SAC for the death of the single stockholder. Not later than 5 days then. So, dapat masabi mo na, manotify mo na yung commission sa pagkamatay ng single stockholder not later than 5 days from the occurrence. Kasama doon yung mga name, address, resident address, contact details ng mga tagapagmana ng single stockholder. So last functions is to call enter nominee and alternate nominee together, kasama yung mga tagapagmana ng single stockholder, and para i-advise din sila sa magaganap na elections for the next single stockholder. Dahil nga namatay na si single stockholder, which is the president and the director and the owner of the one-person corporations, kailangan na mag-appoint or mag-assign, kailangan na pag-meetingan na kung sino yung susunod na magiging single stockholder ng isang one-person corporations. So, with the regards of the elections of the new director, so with the regards, kailangan nga mag-elect kayo ng bagong director na in-amend in the Articles of Incorporations. Dapat yung pag-elections nyo is nakalagay din siya sa Articles of Incorporations ng one-person corporations. Dapat nakapaloob doon yung nakapaloob sa Articles of Incorporations kung paano mag-e-elect ng bagong single stockholder kapag namatay yung or na-aksidente yung kapag namatay yung isang single stockholder. So the one-person corporations can also be designated other functions to the corporate secretary, but this is for functions. You can also use this. So yung mga nabanggit kanina ay pwede pa siya madagdagan ng ibang functions. So pwede pa madagdagan yung mga functions ng isang corporate secretary. Depende sa kung ano gusto ng single stockholder. So, nominee and alternate nominee is being mentioned in sections 123. So, the next sections, which is sections 124, is about nominee and alternate nominee that will be discussed and elaborate by Ms. Sorne. So, and that's all for my report for my report about sections 119 to 123.
So, the section 124, nominee and alternate nominee. The single stockholders shall designate a nominee and the alternate nominee, who shall, in the event of the single stockholder's death or incapacity, take the place of the single stockholders as a director and shall manage the corporation affairs. So, the article of incorporation shall state the name, resident, address, and contact details of the nominee and alternate nominees, as well as the extent and limitation of their authority in managing the affairs of the one-person corporation. So, the written consent of the nominee and alternate nominee shall be attached to the application for the incorporation, such as a consent may be withdrawn in a writing any time before the death of the single stockholders. So meaning, kapag si single stockholders ay may nangyari sa kanya na namatay na aksidente o na-comatose, merong papalit sa kanya. Yan is yung the nominee or the alternate nominee shall be designated. So, pwede rin kapag si nominee ay hindi available, si alternate nominee ang papalit para gampanan ang tungkulin ni stockholder. So, in this section, it's simple that na kahit anong mangyari sa'yo as a stockholders, mayroong papalit or sasalo sa'yo to continue your business or corporation. So the next one is section 125, terms of nominee and alternate nominee. When the incapacity of the single stockholder is temporary, the nominee shall sit as a director and manage the affairs of the one-person corporation until the stockholders, by myself, determination, regains the capacity to assume such duties. In case of death or permanent incapacity of the single stockholders, the nominee shall sit as a director and manage the affairs of the one-person corporation until the legal heirs of the single stockholders have been lawfully determined, and the heirs have designated one of them or have agreed that the estate shall be the single stockholders of the one-person corporation. The nominee shall sit as a director and manage the one-person corporation in case of the nominee's inability, incapacity, death, or refusal to discharge the function as a director and manager of the corporation, and only for the same term and under the same condition applicable to the nominee. So at this point naman, kapag na-injured lang or nabandado lang ng bahagya si stockholders, after what happened sa kanya, pwede siyang anytime bumalik para i-manage yung business niya ulit. Dahil pwedeng kapag minor capacity lang, si nominee or alternate nominee is temporary capacity lang. Then, in the second stanza was kapag yung stockholders is tuluyang namatay na or pwedeng maging permanent capacity si nominee or alternate nominee, pero not all that long term. Dahil pwede rin palitan siya ng mga kamag-anak ng stockholders to continue one-person corporation. Pero if ever man na hindi magkasundo, ang legal heirs at nominee or alternate nominee, ang estate ang magde-decide kung sino ang papalit or ang magmamanage ng one-person corporation. That's all. Then, the next one is Section 126, change of the nominee or alternate nominee. The single stockholders may admit the time change in nominee and alternate nominee by submitting to the Commission of the names of the new nominees and their corresponding written consent. For this purpose, the articles of the incorporation need not by the amended. So, at this moment naman, pwedeng mag-change ng nominee or alternate nominee depends on for example is, niloko or may ginawang hindi maganda si nominee or alternate nominee sa corporation or pwede rin sa stockholders. Pwedeng palitan siya anytime, depende kay stockholders kung sinong gusto niyang pagkatiwalaan or ipalit sa nominee or alternate nominee niya noong nauna. That's all. Then the next one is Section 127, Minutes Book a one-person corporation shall maintain a minute book which shall contain all the actions, decision, and resolution taken by the one-person corporation. So dito naman is maintaining the plans and decision na sa tingin mo kung saan mag-work yung one-person corporation mo. Then, the last one is Section 128, records in lieu of meeting. When action is needed on any matter, it shall be sufficient to prepare a written resolution, signed and dated by the single stockholders and recorded in the minutes book of the one-person corporation. The date of recording in the minute books is the date of the dates in the meeting for all the purposes under the code. So, parang ang pagkakaintindi ko dito is meeting by yourself or pwede ding meeting with your employer or your officer. Simple as that. And that's all. Thank you.
Hi, my name is Riza Pacumberta and I will be discussing Special Corporations, Chapter 3, One-Person Corporation, Sections 129 to 132. Under Special Corporations, Chapter 3, One-Person Corporation, Section 129 is the reportorial requirements. The one-person corporation shall submit the following requirements that I will mention within a period as the Commission may prescribe. So the first reportorial requirement is an annual financial statements audited by an independent certified public accountant, provided that if the total assets or total liabilities of the corporation are less than 600,000 pesos. The financial statements shall be certified under oath by the corporation's treasurer and president. Second is a report containing explanations or comments made by the president on every qualifications, reservations, or adverse remarks or disclaimer made by the auditor in the latter's report. Third is a disclosure of all self-dealings and related party transactions entered into between by the one-person corporation and a single stockholder. And lastly is other reports as the Commission may require. For the purpose of this provision, the one-person corporation must indicate in their articles of incorporation their fiscal year or in the absence thereof the calendar year. So the one-person corporation shall submit those documents that I have mentioned within a period that the SEC required. Whereas for the annual audited financial statements, it must be submitted 120 days from the end of their fiscal year or calendar year indicated in the Articles of Incorporation. So take note that the Securities and Exchange Commission may place the corporation under delinquent status if they fail to submit those reportorial requirements 3 times consecutively or intermittently within the period of 5 years. Still under one-person corporation, Section 130 is about the liabilities of a single shareholder. Section 130 sets out 3 rules governing the liabilities of a single shareholder. First is the burden of proof to show the one-person corporation was adequately financed. The single stockholder may claim limited liability only when he has discharged the burden of affirmatively showing that the corporation was adequately financed. Second is the burden of proof to show the one-person corporation was independent of the stockholder's personal property, where the single stockholder cannot prove that the property of the one-person corporation is independent of stockholder's personal property. So the stockholder shall be jointly and severally liable for the debts and other liabilities of the one-person corporation. And third is invoking the Persing Doctrine. The principles of Persing the corporate veil applies with equal force to one-person corporation as with the other corporation. Section 131 is about the conversion from an ordinary corporation to a one-person corporation. Under Section 131, when all the shares of a record of an ordinary corporation are acquired by a single stockholder who must be a natural person, he or she may do the following. First, he or she may apply for conversion into one-person corporation and subject to the submission of such documents as the SEC may require. Second, if the application for conversion is approved, the SEC shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. And third is the rule on succession of liabilities. The one-person corporation converted from an ordinary corporation shall succeed the latter and be legally responsible for the ordinary corporation's outstanding liabilities as of the date of conversion. Section 132 is about the conversion of a one-person corporation to an ordinary stock corporation. Under Section 132, a one-person corporation can be converted into ordinary stock corporation by first, due notice to be filed with the SEC within 60 days from the occurrence of the circumstances leading to the conversion into an ordinary stock corporation. Second is compliance with all other requirements for stock corporations. And third, when all requirements have been complied with, the SEC shall issue a certificate of filing of amended articles of incorporation reflecting the conversion. And fourth, succession of liabilities. The ordinary stock corporation converted from a one-person corporation shall succeed the latter and be legally responsible for the one-person corporation's liabilities as of the date of conversion. And for the second paragraph of the Section 132, in case of death of a single stockholder, the nominee or alternate nominee shall transfer the shares to the legal heir or estate and notify the SEC of the transfer. Within 60 days from the transfer, the legal heir shall notify the SEC of their decision to either wind up and dissolve the one-person corporation or convert it into an ordinary stock corporation.
Good day everyone, I am Eloise Olimberio and we will be discussing the Title 14, Dissolution. So dissolution is the extinguishment or the death of the franchise of a corporation and the termination of its existence. And even though it is the incorporators that set up a corporation cannot exist without special grant by the state either through a general law, such as the Revised Corporation Code, or a special law. Therefore, what the law itself has granted the law may take away. So for the Section 133, Methods of Dissolution, a corporation formed or organized under the provisions of this code may be dissolved voluntarily or involuntarily. So the thing that gives the corporations its separate juridical personality that is separate from its owner is its corporate existence. But once dissolution is applied, then the corporate existence is already terminated. So, modes of dissolution. Voluntary dissolution may be effected by the vote of the board of directors or trustees and the resolution adopted by the stockholders or members where no creditors are affected. Meaning, the rights of creditors are not prejudiced. So, ibig sabihin, hindi sila nalalamangan or hindi sila naloloko. Walang negative effects sa mga creditors yung pag-dissolve ng corporation kasi usually, nangyayari yan kapag in-insure ng corporation na itong mga creditors nito is nagkaroon talaga sila ng negotiation. Next is by the judgment of the Securities and Exchange Commission after hearing of petition for voluntary dissolution where creditors are affected. So this type of dissolution is used when the creditor's approval to dissolve the corporation cannot be acquired. A petition must be filed with the Securities and Exchange Commission, which will issue a decision after adequate notice and hearing. So letter C is by amending the Articles of Incorporation to shorten the corporate term. So the Articles of Incorporation are revised to reduce the corporation period, and the Securities and Exchange Commission receives the amended Articles of Incorporation. The corporation shall be deemed dissolved upon approval of the amended Articles of Incorporation by the Securities and Exchange Commission, or upon the expiration after those terms as the case may be. So in case of a corporation sold, by submitting to the Securities and Exchange Commission a verified declaration of the dissolution for approval. So setting forth the name of a corporation, reason for dissolution, form, manner, and time when notices were given, names of the stockholders and directors, or members and trustees who approved the dissolution, date, place, and time of the meeting in which the vote was made, and the details of a publication. And last is in case of merger consolidation. So, for involuntary dissolution may be affected by expiration of corporate term provided for in the Articles of Incorporation. So, like for example, kapag parating na yung deadline or yung fixed terms, so dissolve na ang corporation. Unless the time set forth in the original Articles of Incorporation is extended by an amendment to the Articles of Incorporation, a corporation is dissolved when the period set forth in the original Articles of Incorporation expires. By legislative enactment, yung mga corporation na may special charter, so madedissolve lang sila kapag wala sa Articles of Incorporation nila or sa charter nila para ma-dissolve kung kailan, dun pwede silang i-dissolve ng Kongreso. By failure to formally organize and commence its business within 5 years from the date of incorporation, so kapag hinayaan mo lang na matenga yung Articles of Incorporation mo or wala kang initiate, hindi ka nag-start ng business mo within 5 years, the corporation are automatically dissolved. If a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years, the Securities and Exchange Commission may, after due notice and hearing, place the corporation under delegate status. A delegate corporation shall have a period of 2 years to resume operations and comply with all requirements that the Securities and Exchange Commission shall prescribe. Failure to comply with the requirements and resume operations within the period given by the Securities and Exchange Commission shall cause the revocation of the corporation's certificate of incorporation. The last one is by order of the Securities and Exchange Commission on grounds under existing laws. So if a corporation does not formally organize and begin conducting business or constructing works within 5 years of its incorporation, its certificate of incorporation is deemed revoked as of the day following the end of the 5-year period unless the failure is due to circumstances beyond its control. So the dissolution of a corporation is accomplished by the cessation of its corporate powers. So for the Section 134, voluntary dissolution where creditors are affected if dissolution of a corporation does not prejudice the rights of any creditor having a claim against it. So, ibig sabihin, walang negative effects sa creditor kahit na ma-dissolve ang corporation. So, the dissolution may be affected by majority vote. Yan, kung mga majority na nandito. Majority vote of the Board of Directors or Trustees and by a resolution adopted by the affirmative vote of the stockholders owning at least majority of the outstanding capital stock or majority of the members of a meeting to be held up on the call of the directors or trustees. At least 20 days prior to the meeting, notice shall be given to each shareholder or member of record personally, by registered mail, or by any means of authorized under its bylaws, whether or not entitled to vote at the meeting in the manner provided in Section 50 of this code and shall state that the purpose of the meeting is to vote on the dissolution of the corporation. Notice of the time, place, and object of the meeting shall be published once prior to the date of the meeting in the newspaper published in the place where the principal office of said corporation is located, or if no newspaper is published in such a place, in a newspaper of general circulation in the Philippines. So dito is puro mga notice lang yan. Yan. A verified request for dissolution shall be filed with the Commission. The kung saan ito ang mga nilalaman, the reason for the dissolution, bakit kayo nag-dissolve, the form, manner, and time when the notices were given, names of the stockholders and directors or members and trustees who approved the dissolution, the date, place, and time of the meeting in which the vote was made, and details of publication. The corporation shall submit the following to the Commission. The first one is a copy of the resolution authorizing the dissolution, certified by majority of the Board of Directors or Trustees and countersigned by the Secretary of the Corporation. Second is group of publication, and the last one is favorable recommendation from the appropriate regulatory agency when necessary. Within 15 days from receipt of the verified request for dissolution, and in the absence of any withdrawal, so ibig sabihin, walang pwedeng mag-back out, tuloy ang dissolution. Within said period, the Commission shall approve the request and issue the certificate of dissolution. The dissolution shall take effect only upon the issuance by the Commission of a certificate of dissolution. So, tsaka lang nagkakaroon ng effect yung dissolution kapag nag-issue na ng certificate of dissolution si Commission. So, no application for dissolution of banks, banking, and quasi-banking institutions, pre-need, insurance and trust companies, NSSALS, pawn shops, and other financial intermediaries shall be approved by the Commission unless accompanied by a favorable recommendation of the appropriate government agency. So, usually, mga ano to, like central bank, mga insurance commission, on. So that's it for the section 133 and 134. Proceed to the next reporter, please.
Good day everyone, my name is Jamaica Sibay. I'm going to discuss the section 135 to 137. Section 135, this is a voluntary dissolution where the creditor are affected. This type of dissolution is used when the creditor approval to dissolve the corporation is not possible to acquire. This part is started by a petition filed with the Securities and Exchange Commission, which will deliver a decision after adequate notice and hearing. The SEC shall render judgment dissolving the corporation and directing such disposition of its assets as justice requires, and may appoint a receiver to collect such assets and pay the corporation debt, or in summary, take charge of the corporation liquidation after finding that material allegations in the petition are true, and after resolving objective thereto. Remember, the dissolution will only take effect if the SEC issue a certificate of dissolution. Pag walang certificate of dissolution, hindi madidissolve ang corporation. And now, for the procedure for voluntary dissolution where the creditor are affected. First step is the petition in Section 134 resolution, and Section 35 is the majority of the Board of Directors or trustee must sign a petition for dissolution which must be confirmed by the corporation president or secretary or one of director or trustee, and must include all claim and demand against the corporation. Example, ilalagay nyo is si A ay may utang na ganito and B may utang na ganito. So on, madami pong pwedeng ilagay the petition for dissolution. So, the content of the petition for dissolution, this is first, the reason for the dissolution. Second, the form, and manner, and time when the notice were given. Remember na kailangan ipa-approve sa mga stockholder, so we need a meeting na naman. The last, the date, place, and time of the meeting in which the vote was made. Then let's talk about the accompanying document to the petition for dissolution. First, a copy of the resolution authorizing the dissolution, signed by the Secretary of a company and certified by the majority of the Board of Director or Trustee. This is only for BOD or the Board of Director. For stockholder naman is yung mismong petition na. Then next, the list of all its creditors. Remember, in petition, we have to set forth all claim and demand against the corporation. For the second procedure, a meeting of stockholder or member called for the purpose. For this reason, a meeting of stockholder or member is convened. And the third, approval of the petition for the solution by the affirmative vote of the stockholder representing at least 2/3 of outstanding capital stock or by at least 2/3 of the member. Third, investor representing at least 2/3 of outstanding capital stock or at least 2/3 of member must vote affirmatively on the petition for dissolution. Again, the difference of 134 is majority ng pagdating sa stockholder, and for 135 its petition must be approved by 2/3 OCS or 2/3 of the members. For the submission to the Security Exchange Commission of the petition for dissolution, if the petition is sufficient in form and content, the Security Exchange Commission shall set a deadline for the filing objection to the petition in an order, which means time or date of petition, stating the petition purpose. This date shall not be fewer than 30 days, nor more than 60 days after the order is entered, and the copy of the order must be published before that date. A copy of order must be published at least one a week for 3 weeks prior to the date in a board circulation publication published in the municipal or city where the corporation primary office is located. Alternatively, if no such publication exists, a comparable copy should be displayed in 3 public locations in such municipal or city for the 3 consecutive weeks in the newspaper. Upon 5 days, notice given after the date in which the right to file objective fixed in the order has expired. If no such objection is adequate and the substantive claim of the petition are accurate, the Security Exchange Commission shall pronounce judgment dissolving the company and directing such disposal of its assets as a justice demand, and may appoint a receiver to collect such assets and pay the corporation debt. Now, let's talk about Section 136, the dissolution by shortening corporate term. It is in fact if the article of incorporation are revised to reduce the corporation period, and the new article of incorporation are filed with the Securities and Exchange Commission. The corporation shall be presumed dissolved upon approval of the altered articles of incorporation by the SEC or at the expiration of the reduced term, as the case may be, without any additional processes save liquidation. In this section, pag walang approval ng Security and Exchange Commission, hindi madidissolve yung corporation. Kaya need niya i-approve ng Securities and Exchange Commission. Section 137, the withdrawal of request and petition for the dissolution. First rule regarding withdrawal of request for dissolution, the request for the dissolution must be withdrawn in writing, properly confirmed by any incorporator, director, trustee, shareholder, or member, and signed by the same number of incorporator, director, trustee, shareholder, or member as are required to find dissolution under Section 134 of the RCC. And the withdrawal must be made within 15 days of the Securities and Exchange Commission receiving the request for the resolution. So, bago ma-approve ng Securities and Exchange Commission, ma-file na yung withdrawal. The Securities and Exchange Commission will postpone action on the request for dissolution if it receives a withdrawal of the request for dissolution nyo. Kailangan ng investigation. Then after investigation, the Securities and Exchange Commission issue a declaration that the petition for dissolution has been withdrawn, and also they call a combined meeting of the Board of Directors or trustee and the stockholder or member to decide whether to dissolve the corporation, kung tuloy ba or hindi ang isang request for dissolution. Moreover, the Securities and Exchange Commission may issue any order if deemed necessary. Then, paano naman if the withdrawal of the petition for dissolution, which is filed to under Section 135 with the petition for dissolution? A withdrawal of petition for dissolution should be in the form of the motion. It shall be similar in substance to a withdrawal of request for dissolution, but it must be verified and filed out prior to the publication of the decision, setting the deadline for the filing of objection to the petition. Remember, in Section 135, pagkatanggap ng Securities Exchange ng petition for dissolution together with the accompanying document, mag-i-issue siya ng order or date or time which will recite the purpose of the petition. So, bago mag-issue ng Securities and Exchange Commission, ma-file mo na yung motion mo kasi nagbibigay ng order ang Securities and Exchange Commission. That's all for voluntary dissolution.
I'm Jobilin Rapisura, and I will explain the Section 138 of the Revised Corporation Code, which explains the involuntary dissolution. So what is involuntary dissolution? It is when the dissolution is ordered by the SEC or SEC, motu proprio, or upon filing by a verified complaint by any interested party. So this would be the ground of SEC for that dissolution. First would be the non-use of corporate charter as provided under Section 21 of this code. The Section 21 is already discussed by the past reporter. So next ground would be continuous in operation of a corporation as provided under Section 21 of this code. So if a corporation has commenced its business but subsequently becomes inoperative for a period of at least 5 consecutive years, the SEC or the Commission may, after due notice and hearing, place the corporation under the delinquent status. A delinquent corporation shall have a period of 2 years to resume operations and comply with all the requirements that SEC may prescribe. So the next ground would be upon receipt of a lawful court order dissolving the corporation. So if the corporation has a case before and the court has found that the corporation should be dissolved. Next ground would be upon finding by final judgment that the corporation procured its incorporation through fraud, meaning that the incorporation was fraudulent. And the last ground would be upon finding by final judgment that the corporation would be first was created for the purpose of committing, concealing, or aiding the commission of securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices. Second would be it is committed or aided in the commission of securities violation, smuggling, tax evasion, money laundering, or graft and corrupt practices, and its stockholders do that. And last would be repeatedly and knowingly tolerated the commission of graft and corrupt practices or other fraudulent or illegal acts by its directors, trustees, officers, or employees. So, if the corporation is ordered dissolved by final judgment pursuant to the grounds set forth in subparagraph hereof, its asset, after payment of its liability, shall upon petition of the Commission with the appropriate court be forfeited in the favor of the national government, without prejudice to the rights of innocent stockholders and employees for services rendered, and to the application of other penalty or sanction under this code or other laws. So the Commission shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to the involuntary dissolution of companies under their special regulatory jurisdiction. So next would be liquidation. So liquidation is also known as the winding up of affairs. It is a process by which all the assets of the corporation are converted into liquid assets or cash in order to facilitate payment of obligation to creditors, and the remaining balance, if there is any, you give or distribute that to the stockholders or members. So according to Section 139 of this code, corporate liquidation, except for banks, which shall be covered by the applicable provision of Republic Act Number 7653, otherwise known as the New Central Bank Act, as amended, and Republic Act Number 3591, otherwise known as the Philippine Deposit Insurance Corporation Charter, as amended, every corporation whose charter expires pursuant to its articles of incorporation is annulled by forfeiture, or whose corporate existence is terminated in any other manner, shall nevertheless remain as a body of corporate for 3 years after the effective date of dissolution, for the purpose of prosecuting and defending suits by or against it, and enabling it to settle and close its affairs, dispose of and convey its property, and distribute its assets, but not for the purpose of continuing the business for which it was established. At the given 3 years time, the corporation is authorized and empowered to convey all of its property to trustees for the benefit of stockholders, members, creditors, and other persons in interest. After such conveyance by the corporation, all interest which the corporation had in the property terminates, the legal interest vests in the trustee, said the beneficial interest in the stockholders, members, creditors, or other persons in interest. So, except as otherwise provided for in Section 93 and 94 of this code, upon the winding up of the corporate affairs, any asset distributable to any creditor, stockholder, or member who is unknown or cannot be found shall be handed over in favor of the national government, except by decrease of capital stock and as otherwise allowed by this code. No corporation shall distribute any of its assets or property except upon lawful dissolution and other payment of all its debts and liabilities. So that's it for Title 14 Dissolution from Section 133 to 139. Thank you.
Good day, everyone. My name is Joanna Lorraine Paulito.
Julian Morit Cabanilla.
And Livon Dane Dahonan to discuss the Title 15 of the Revised Corporation Code of the Philippines.
Good day, everyone. I'm Julian Morit Cabanilla, and I'm here to discuss the first 5 sections under Foreign Corporation. Let us first define the foreign corporation. Foreign corporation is one that does operation in state other than the one in which its owners registered it. The foreign state's laws may compel the shareholders to register the firm as a foreign corporation and may state taxes depending on the company's operations. Section 140, Definition and Rights of Foreign Corporation. For purposes of this code, a foreign corporation is one formed, organized, or existing under laws other than those of the Philippines and whose laws allow Filipino citizens and corporations to do business in its own country or state. It shall have the right to transact business in the Philippines after obtaining a license for that purpose in accordance with this code and a certificate of authority from the appropriate government agency. Before conducting business in the Philippines, a foreign firm must get a license and a certificate from the proper government agency. If a foreign corporation does business in the Philippines without any valid license, it is prohibited from filing any sections or procedure in Philippine courts, as established by Section 150 of the Revised Corporation Code. Section 141, Application to Existing Foreign Corporation. Every foreign corporation which on the date of the effectivity of this code is authorized to do business in the Philippines, under a license therefore issued to it, shall continue to have such authority under the terms and conditions of its license, subject to the provisions of this code and other special laws. Section 142, Application for a License. A foreign corporation applying for a license to transact business in the Philippines shall submit to the Securities and Exchange Commission a copy of its articles of incorporation and bylaws, certified in accordance with law, and their translation to an official language of the Philippines, if necessary. The application shall be under oath, and unless already stated in these articles of incorporation, shall specifically set forth the following. Number 1, the date and term of incorporation. Number 2, the address including the street number of the principal office of the corporation in the country or the state of incorporation. Number 3, the name and address of its resident agent authorized to accept summons and process in all legal proceeding, and pending the establishment of local office. All notices affecting the corporation. Number 4, the place in the Philippines where the corporation intends to operate. Number 5, the specific purpose or purposes which the corporation intends to pursue in the transaction of the business in the Philippines, provided that the said purpose or purposes are those specifically stated in the certificate of authority issued by the appropriate government agency. Number 6, the names and addresses of the present directors and officers of the corporation. Number 7, a statement of its authorized capital stock and aggregate number of shares which the corporation has authority to issue, itemized by classes, par value of shares, shares without par value, and series if any. Number 8, a statement of its outstanding capital stock and the aggregate number of shares which the corporation has issued, itemized by classes, par value of shares, shares without par value, and series if any. Number 9, a statement of the amount actually paid in. And number 10, such additional information as may be necessary or appropriate in order to enable the Securities and Exchange Commission to determine whether such corporation is entitled to a license to transact business in the Philippines, and to determine and assess the fees payable. Section 143, Issuance of a License. If the Securities and Exchange Commission is satisfied that the applicant has compiled all the requirements of this code and other special laws, rules, and regulations, the Commission shall issue a license to the applicant to transact a business in the Philippines, for the purpose or purposes specified in such license. Upon issuance of a license, such foreign corporation may commence to transact business in the Philippines. and continue to do so for as long as it retains its authority to act as a corporation under the laws of the country or state of its incorporation, unless such license is sooner surrendered, revoked, suspended, or annulled in accordance with this code or other special laws. If the Securities and Exchange Commission is satisfied that the applicant has met all the requirements of this code, as well as any other special laws, rules, and regulations, the Commission will grant the applicants a license to conduct business in the Philippines for the purpose or purposes specified in the license. Because the SEC will only provide a license if the foreign corporation has met all legal criteria. It is satisfied that the applicant's bylaws, among other papers, fulfill the legal standard when it decides to issue such license. This essentially means that the foreign corporation's bylaws have been approved. It may not have been stated explicitly, but it is unmistakably an endorsement. As a result, bylaws of the petitioner bank while coming from a foreign jurisdiction are legitimate and effective in the Philippines. Section 144. Who may be a resident agent? A resident agent may be either an individual residing in the Philippines or a domestic corporation lawfully transacting business in the Philippines, provided that in case of an individual, he must be good moral character and of sound of financial standing. Provided further that in case of a domestic corporation who will act as a resident agent, it must be likewise be of sound financial standing and must show proof that it is in good standing as certified by the Commission. Two classification of resident agent. Number 1, an individual who lives in the Philippines must be of excellent moral character and have a stable financial position. Next is a domestic corporation. Legitimately undertaking business in the Philippines must also be in good financial standing and exhibit documentation or such status as verified by the Securities and Exchange Commission or SEC. Purpose of appointing a resident agent. For the purpose of accepting and receiving on behalf of the foreign corporation, number 1, notice concerning the corporation while its local office is being established, and number 2, in all procedures for or against company, summon, and other legal processes are used. Take note that the appointment of a foreign corporation's resident agent can be withdrawn at any time by the corporation.
Section 145, Resident Agent Service of Process. As a condition to the issuance of license for a foreign corporation to transact business here in the Philippines, such corporation shall file with the Commission a written power of attorney designating a person who must be a resident of the Philippines, on whom summons and other legal processes may be served in all actions or other legal proceedings against such corporations. Such foreign corporation shall likewise execute and file within the Commission an agreement or stipulation executed by the proper authorities of the said corporation. Whenever such service of summons or other process is made upon the Commission shall transmit by mail a copy of such summons or other legal processes to the corporation at its home office or principal office within 10 days, and the sending of such copy by the Commission shall be a necessary part and shall complete such service. And so, resident agent acts as the representative of a foreign corporation. So, the primary function of a resident agent is to receive, in behalf of the foreign corporations, notices, summons, and other legal processes in connection with actions against such corporation. Also, resident agent has no control over the assets of the corporation. Take note that the service of any such papers on such resident agent has the same force and effects as if made upon duly authorized officers of the foreign corporation at its home office. Section 146, Law Applicable. A foreign corporation lawfully doing business here in the Philippines shall be bound by all laws, rules, and regulations applicable to domestic corporations of the same class, except those which provide for the creation, formation, organization, or dissolution of corporations, or those which fix relations, liabilities, responsibilities, or duties of stockholders, members, or officers of corporation to each other or to the corporation. So when it comes to the operational or mga transactions ng isang foreign corporation, here in the Philippines, Philippine laws ang ma-apply. But when it comes to the organizational or internal affairs of the corporation, the laws of state of creation is applied. Or ito yung mga laws kung saan na-incorporate ang isang corporation. So this also includes the rights of stockholders in a foreign corporation. Section 147. Amendments of Articles of Incorporation or Bylaws of Foreign Corporations. Whenever the Articles of Incorporation or Bylaws of a foreign corporation authorizing stock business here in the Philippines are amended, such foreign corporation shall file with the Commission within 60 days after the amendment becomes effective. And in proper cases, with the appropriate government agency, a duly authenticated copy of the amended Articles of Incorporation or bylaws indicating clearly in capital letters or underscoring the changes made and duly certified by the authorized official or officials of the country or state of incorporation. Such filing shall not in itself enlarge or alter the purpose or purposes for which such corporation is authorized to transact business here in the Philippines. So when a foreign corporation's bylaws are amended, you need to file with the Commission within 6 days after the amendments becomes effective. The corporation need to issue an authenticated copy of the amended bylaws clearly indicating the changes made, or in capitalized letters. Dapat din na certified by the authorized officials or officials of the country kung nasaan in-incorporate ang isang corporation. Section 148. Amended License. A foreign corporation authorized to transact business here in the Philippines shall obtain an amended license in the event it changes its corporation name or desire to pursue other or additional purposes in the Philippines by submitting an application with the Commission, favorably endorsed by the appropriate government agency in the proper cases. So just like other license, the amended license serves as a proof that the law grant or allow them to perform activities by which the foreign corporation amended. Section 149, Merger or Consolidation involving a foreign corporation licensed in the Philippines. So first, let's define what is merger and consolidation. During merger, essentially, other corporation or corporate entities become a part of an existing entity, or simply, A plus B is equals to A or B. While in consolidation is when multiple companies join to form a new entity, or simply, A plus B is equals to C. So Section 149 states that one or more foreign corporations authorized to transact business here in the Philippines may merge or consolidate with any domestic corporations if permitted under the Philippine laws and by the law of its incorporation, provided that the requirements on merger or consolidation as provided in these codes are followed. Whenever a foreign corporation authorized to transact business here in the Philippines shall be a party to a merger or consolidation in its home country or state as permitted by the law authorizing its incorporation. And such foreign corporation shall file with the Commission within 60 days after the effectivity of such merger or consolidation and in proper cases with the appropriate government agency, a copy of the articles of merger or consolidation duly authenticated by the proper official or officials of the country or state under whose laws the merger or consolidation was affected, provided, however, if the absorbed corporation is the foreign corporation doing the business in the Philippines, the latter shall at the same time file a petition for withdrawal of its license in accordance with this title.
Under Section 150 of the Revised Corporation Code of the Philippines, no foreign corporation transacting business in the Philippines without a license or its successors or assigned shall be permitted to maintain or intervene in any action, suit, or proceeding in any court or administrative agency of the Philippines. But such corporations may be sued or proceeded against before Philippine courts or administrative tribunals or any valid cause of action recognized under Philippine laws. Basically, foreign corporations must actually transact business in the Philippines, specifically within the Philippine territory. It is an essential requisite for the Philippines to acquire jurisdiction over foreign corporations. Thus, foreign corporations shall secure Philippine business license. As a general rule, the aforementioned provision prevents an unlicensed foreign corporation doing business in the Philippines from accessing our courts. An exemption to this rule is the doctrine of estoppel. Section 151 of the Revised Corporation Code tackles about revocation of license. Without prejudice to other grounds provided under special laws, the license of a foreign corporation to transact business in the Philippines may be revoked or suspended by the Commission upon any of the following grounds: failure to file its annual report or pay any fees as required by this code, failure to appoint or maintain a resident agent in the Philippines as required by this title, failure after change of its resident, agent, or address to submit to the Commission a statement of such change as required by this title, failure to submit to the Commission an authenticated copy of any amendment to its articles of incorporation or bylaws or of any articles of merger or consolidation within the time prescribed by this title, a misrepresentation of any material matter in any application, report, affidavit, or other document submitted by such corporation pursuant to this title, failure to pay any and all taxes, imposts, assessments, or penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions, transacting business in the Philippines outside of the purpose or purposes for which such corporation is authorized under its license, transacting business in the Philippines as agent of or acting on behalf of any foreign corporation or entity not duly licensed to do business in the Philippines, or any other ground as would render it unfit to transact business in the Philippines. Under Section 152, issuance of certificate of revocation. Upon the revocation of the license to transact business in the Philippines, the Commission shall issue a corresponding certificate of revocation, furnishing a copy thereof to the appropriate government agency in the proper cases. The Commission shall also mail the notice and copy of the certification of revocation to the corporation at its registered office in the Philippines. Section 153 of the Revised Corporation Code of the Philippines tackles about withdrawal of foreign corporations subject to existing laws and regulations. A foreign corporation licensed to transact business in the Philippines may be allowed to withdraw from the Philippines by filing a petition for withdrawal of license. No certificate of withdrawal shall be issued by the Commission unless all the following requirements are met. Number 1, all claims which have accrued in the Philippines have been paid, compromised, or settled. Number 2, all taxes, imposts, assessments, penalties, if any, lawfully due to the Philippine government or any of its agencies or political subdivisions have been paid, and the petition for withdrawal of license has been published once a week for 3 consecutive weeks in a newspaper of general circulation in the Philippines. That's all for my report. Thank you.
Title 16: Investigations, Offenses, and Penalties. So, alam nyo ba na yung SEC ngayon or yung Securities Exchange and Commission under the Revised Corporation Code, mas binigyan na siya ng authority to act on complaints as regards corporations. Under Section 154, the SEC may investigate an alleged violation of this code or of a rule, regulation, or order. So, hindi lang violation ng RCC, even violation ng SEC rule, SEC regulation, at SEC order ay kasama. The SEC may publish its findings, orders, opinion, advisories, or information concerning any such violation as may be relevant to the general public or to the parties concerned, subject to the provisions of Republic Act 10173, otherwise known as the Data Privacy Act of 2012, and other pertinent laws. So, kung relevant to the general public sa tingin ng SEC, pwede na nilang i-publish yung findings, but ang limitation, it must be subject to the Data Privacy Act and other pertinent laws. SEC shall give reasonable notice to and coordinate with the appropriate regulatory agency prior to any such publication involving companies under the regulatory jurisdiction. So, reasonable notice lang ang ibibigay ng SEC, but still ipapublish pa rin nila. Yung point is, basta sa tingin ng SEC na relevant to the public yung findings nila, then they can publish it. So, next is Section 155. The Commission, through its designated officer, may administer oaths and affirmations, issue subpoena and subpoena duces tecum, take testimony in any inquiry or investigation, and may perform other acts as necessary to the proceedings or to the investigation. Ito yung power ng SEC through its designated officer. Pwede na silang mag-administer ng oath. So, para silang notary public, pwede kang manumpa sa kanila at pwede din sila mag-issue ng subpoena. So, ano nga ba yung subpoena? Subpoena is a letter. Example, nagpadala ang SEC ng subpoena. Pwede ka nilang i-compel to appear before them. And hindi lang subpoena, pwede din sila mag-issue ng subpoena duces tecum na kung saan pwede ka nilang pilitin na dalhin yung mga dokumento na kailangan nila. And to take testimony, so mapapansin natin yung power na mayroon ng SEC. Also, they can perform any other acts necessary to their investigation in which hindi ka pwedeng tumanggi. Next is Section 156. The SEC may issue cease and desist order. That means, pwede ka nilang patigilin sa anumang ginagawa mo. Yun yung cease and desist order. Whenever it has reasonable basis to believe that a person has violated or is about to violate this code, a rule, regulation, or order of the SEC. Imagine yung power na mayroon ng SEC. Na kung sa tingin nila may reasonable basis sila to believe that a person has violate or about to violate, then they can issue cease and desist order. SEC may issue a cease and desist order ex parte to enjoin an act or practice which is fraudulent or can be reasonably expected to cause significant, imminent, and irreparable danger or injury to public safety or welfare. So, ano nga ba yung ex parte? In this case, hindi pa naririnig yung panig ng kabilang party, but still, si SEC pwede na siyang mag-issue ng cease and desist order or yung tinatawag nga na ex parte, provided na ang pinag-i-issuehan nito ay corporation na may fraudulent act na ginagawa. Lagay naman dito, 'di ba? And is expected to cause significant, imminent, and irreparable danger or injury to public safety or welfare. So, kung titingnan natin, reasonable naman siya na kahit hindi pa naririnig yung kabilang party, ay pwede na mag-issue ng cease and desist order ng SEC ex parte. Kasi nga, ang involved na dito is yung public safety or welfare. So, di ba may karapatan tayo for notice or yung tinatawag na right to notice and the right to be heard? And contradicting siya dito, but may mga pagkakataong binibigyan ng power ng batas ang katulad nito na ex parte. The ex parte order shall be valid for a maximum period of 20 days without prejudice to the order being made permanent after due notice and hearing. So, may limitation pa itong ex parte as to validity. So, sinabi nga dito na ex parte order is valid for a maximum of 20 days at magiging permanent lang siya after due notice and hearing. Thereafter, the SEC may proceed administratively against such person in accordance with Section 158 of this code and or transmit evidence to the Department of Justice for preliminary investigation or criminal prosecution and or initiate criminal prosecution for any violation of this code, rule, or regulation. So ngayon, after ng hearing na patigil na ng SEC yung fraudulent act na ginagawa ng isang corporation, pwede nang kasuhan ng SEC administratively or if during notice and hearing ay may criminal liability yung person na yon, the SEC will transmit evidence to DOJ for preliminary investigation para makasuhan ng criminal case. So, mapapansin natin, dalawa agad yung pwedeng maging kaso, administrative case under SEC jurisdiction or criminal case under DOJ jurisdiction. Section 157, Contempt. Usually kasi kung may subpoena power ang isang agency, tulad ng SEC, mayroon din itong contempt powers. So ano nga ba yung contempt? A person who, without justifiable cause, fails or refuses to comply with any lawful order, decision, or subpoena issued by the Commission shall, after due notice and hearing, be held in contempt and fined in an amount not exceeding 30,000 pesos. So, ito yung pamamaraan ng SEC to compel any person na na-issuehan ng subpoena to appear before them. Yun yung tinatawag natin na contempt. So, once na-held in contempt na ang isang tao, may fine siya na kailangang bayaran na hindi lalampas sa 30,000. When the refusal amounts to clear and open defiance of the Commission's order, decision, or subpoena, the Commission may impose a daily fine of 1,000 pesos until the order, decision, or subpoena is complied with. Ito yung mas mabigat. Pag nag-refuse ka, may daily fine ka na 1,000 hanggang sa sumunod ka. So, sana ni-imagine nyo na yung contempt powers. Section 158, Administrative Sanctions. If after due notice and hearing, the Commission finds that any provision of this code, rules or regulations, or any of the Commission's orders has been violated, the Commission may impose any or all of the following sanctions, taking into consideration the extent of participation, nature, effects, frequency, and seriousness of the violation. So, ito yung sinasabi ko kanina na may power si SEC to institute administrative case. Ito na yung mga penalties. First,
imposition of fine ranging from 5,000 pesos to 2 million pesos and not more than 1,000 pesos for each day of continuing violation, but in no case to exceed 2 million pesos. So, mapapansin natin na mabigat yung fines under RCC. Second, issuance of permanent cease and desist order. Okay, so ito yung kanina under Section 156. Third, suspension or revocation of the Certificate of Incorporation. Ito yung mga administrative sanctions. Fourth, dissolution of the corporation and forfeiture of its assets under the conditions in Title 14 of this code. Lastly, ito yung involuntary dissolution. Prohibited acts. So, what are the prohibited acts? Under Section 159, we have unauthorized use of corporate name. The unauthorized use of a corporate name shall be punished with a fine ranging from 10,000 pesos to 200,000 pesos. So, di ba sa mga previous lessons natin, nabanggit doon na hindi ka na pwedeng gumamit ng corporate name na existing na. So, kung ikaw ay gumamit ng corporate name na existing na, then unauthorized use of corporate name na yon. So, yung fine na 10,000 to 200,000, mabigat-bigat din siya, di ba? So, for other prohibited acts under this code, i-continue siya ng next reporter. Thank you.
Hello everyone. I will discuss about the Revised Corporation Code, Section 160 to 165. The Revised Corporation Code enumerates the various specific offenses and their corresponding penalties with special emphasis on fraud and graft corrupt practices. First is the unauthorized use of corporate name or the Section 159. This section had been discussed by the previous reporter, so I will discuss the remaining. Next is the violation of disqualification provision or Section 160. This penalty is imposed on directors, trustees, or officers with grounds or qualified for disqualification, which is provided in Section 26. When the directors, trustees, or officers that are qualified for disqualification, pero still, tumakbo pa rin sila for the office as officers, or they willfully conceals or tinago nila yung mga disqualification na yon, those director, trustee, or officer shall be punished with a fine ranging from 10,000 pesos or 200,000 pesos at the discretion of the court, and shall be permanently disqualified from being a director, trustee, officer of any corporation. Hindi lang sa corporation na ito siya permanently disqualified kung saan siya ngayon nakaupo. This disqualification applies to other corporations as well. When the violation of this provision is injurious or detrimental to the public, the penalty shall be fine ranging from 20,000 pesos to 400,000 pesos. Next is the violation to duty to maintain records to allow inspection of reproduction, or Section 160. This is punishable with a fine ranging from 10,000 pesos to 200,000 pesos at the discretion of the court, taking into the consideration the seriousness of the violation and its implications. When the violation of this provision is injurious or detrimental to the public, the penalty is a fine ranging from 20,000 pesos to 400,000 pesos. The penalties imposed under this section shall be without prejudice to the Commission's exercise of its contempt powers under the Section 157 hereof. Please take note that these are the punishable acts. First is failure to keep bylaws in principal office of the corporation and failure to subject the name to inspection or Section 45. Next, failure to keep documents, books, and records such as the articles of incorporation, bylaws, list of the stockholders or members, list of members of the board, record of all business transactions, including the financial statements, resolutions, reportorial requirements, minutes, stock, transfer book, if applicable, and is subject to the same to inspection, or the Section 73. Next, failure to keep a list of members and their proxies and failure to update such 20 days prior to any scheduled election, or Section 92. Next, failure to prepare a written resolution of any action and record the same in the minute book of the one-person corporation, or Section 128. Remember na sa one-person corporation, walang meeting na nagaganap dyan. Meron lang resolution which will be prepared. The single stockholder will sign the resolution and the resolution will be recorded in the minute book of the one corporation in lieu to the meeting. Next is the failure to submit the SEC reportorial requirements such as the annual financial statements, general information sheet, and the director or trustee compensation report and appraisal or performance report in case of the corporations vested with the public interest. Now let's move on to the next offense and penalties. The willful certification of incomplete, inaccurate, false, or misleading statements or reports, or Section 162. Any person, this may include also independent auditor, who willfully certifies a report required under this code, knowing that the same contains incomplete, inaccurate, false, or misleading information or statements, shall be punished with a fine ranging from 20,000 pesos to 200,000 pesos when wrongfully certification is injurious or detrimental to the public. The auditor or any responsible person may also be punished with a fine ranging from the 40,000 pesos to 400,000 pesos. Now, let's move on to the next one. The Independent Auditor Collusion, or Section 163. Remember, in this section, yung independent auditor or yung auditor ng isang corporation is in connivance or in collusion with the directors or representative of the corporation. Anong ibig sabihin nito? Collusion means nagsasabatan sila. The auditor still certifies yung financial statements even if it is incomplete or inaccurate and there is a failure to give accurate financial statements condition. Sinertify niya pa rin kahit na alam niyang mayroong misleading or inaccurate statements yung financial statements ng corporation. Those auditors and the directors shall be punished with a fine ranging from 80,000 pesos to 500,000 pesos when they are found guilty. When the statement or report certified is fraudulent or has the effect of causing injury to the general public, the auditor or responsible officer may be punished with a fine ranging from 100,000 pesos to 600,000 pesos. Next is obtaining corporate registration through fraud, or Section 164. This is just simply those responsible for the formation of a corporation through fraud or who assisted directly or indirectly therein, shall be punished with a fine ranging from 200,000 pesos or 200,000 pesos to 2 million pesos when the violation of this provision is injurious or detrimental to the public. The penalty is fine ranging from 400,000 pesos to 5 million pesos. And lastly, the fraudulent conduct of business, or Section 165. A corporation that conducts its business through fraud shall be punished with a fine ranging from 200,000 pesos to 2 million pesos. When the violation of this provision is injurious or detrimental to the public, the penalty is ranging from 400,000 pesos to 5 million pesos.
Hi, my name is Remy G. Marinas and I will tackle about the continuation of the Title 16 of the Revised Corporation Code of the Philippines entitled Investigations, Offenses, and Penalties, Sections 166 to 172. Let's start. Section 166 states that if the corporate vessel is used for fraud or for committing or concealing graft and corruption practices, the fine is ranging from 100,000 pesos to 5 million pesos. So, yung mga directors, officers, or employees, or yung mga agents or representative ng iisang corporation, kapag sila ay nag-engage in graft and corruption practices and there's a failure on the part of the corporation to install safety measures such as para magkaroon ng mga transparency within the corporation, remember that this is a prima facie evidence of its corporation liability. So, in cases na hindi corporation yung ginamit as the intermediary for graft and corruption, pwede namang maging third person. So, dito papasok yung section 167, which states that a corporation that appoints a third person as an intermediary who will engage in graft and corruption for the corporation's benefit or interest, the fine is ranging from 100,000 pesos to 1 million pesos, which is higher than the section 166. However, in section 168, it states that the corporation that tolerates graft and corruption practices of its directors, trustees, or officers, those directors, trustee, or officers who tolerate such action, lalo na't alam nila na may ganyan nangyayari sa corporation at hindi sila gumawa ng anumang aksyon such as pagre-report or pag-file ng any appropriate actions, this is punishable with a fine ranging from 500,000 pesos to 1 million. This section shows that hindi dapat tinotolerate ang graft and corruption, especially when it comes to its directors, trustees, or officers. In section 169, it defines whistleblower as any person who provides truthful information relating to the commission or possible commission of any offenses or violation under the Revised Corporation Code of the Philippines. Usually, ito yung mga witnesses ng any violations or offenses. The Revised Corporation Code protects the whistleblower by punishing any person who intended to retaliate, take revenge, or commit acts detrimental to a whistleblower. Ano nga ba yung mga acts detrimental to a whistleblower? Ito yung nag-interfere sa lawful employment or livelihood nila. Tulad ng pagtanggal sa trabaho or pag-demote sa kanya or babaan yung sweldo niya, bawal yon kasi pinoprotektahan sila ng Revised Corporation Code of the Philippines. At ang mapapatunayan na nag-commit ng retaliation against whistleblower is punishable with a fine ranging from 100,000 pesos to 1 million. Next is Section 170. Section 144 was adopted under Section 170 of the Revised Corporation Code of the Philippines. It is a general provision for violations on top of other provision on specific violation. Violation which are not otherwise penalized under the Revised Corporation Code are punishable with a fine not less than 10,000 pesos but not more than 1 million pesos. If the violation is committed by the corporation after notice or hearing, be resolved in appropriate proceeding before the commission. So even if the corporation is dissolved, it does not prevent the filing of appropriate action against the director, trustees, or officers of such corporation. Also, on this section, the liability for any of the foregoing offenses shall be separate from the other administrative, civil, or criminal liability under the code or other laws. Let's move on to Section 171. Under this provision, if the offender is a corporation, the penalty or liability may be imposed upon such corporation or upon its directors, trustees, stockholders, members, officers, or employees that is responsible for the violation or indispensable to its commission, subject to the discretion of the court. Finally, we have reached the last section of the Title 16, which is the Section 172, which is the liability of aiders, abettors, or other secondary liability, defined for anyone who will aid, abet, conceal, command, induce, or cause any violation of this code shall be punished with a fine not exceeding that imposed on the principal offenders at the discretion of the court. The court will also take account their participation in the offenses. And that's all for the Title 16 of the Revised Corporation Code. I hope you learned something.
Hi guys, I'm Maria Arcagalope. I will discuss to you the Revised Code Corporation of the Philippines, Title Number 17, Miscellaneous Provision. Section 173, Outstanding Capital Stock, is defined the total shares of stock. It is not necessarily issued, and even it's necessarily issued because it has an exception. Exemption is the treasury of shares, and even it is binding or subscriptions. So, when you say it's capital or capital stock, sometimes ang capital is dividend siya inequally if yun yung napag-usapan or in the contracts or agreement nila. So, for example, A, B, C, and D receive an income of 100,000. So, and then they wanted to be equally divided. So, they have to be a percentage of 25% each. So, in a 25% each, in 100,000, they will have 25,000 each. Okay? Sometimes naman, it depends on the percentage na nakukuha nila. Like, or shares. If A is mas mataas yung shares niya sa kay B, C, and D, so mas mataas yung commission niya or income niya. Okay? Next one is the Section 174, designation governing of boards. It is defined as the management or the corporation of the company. For example, may 5 members kayo in the management. Hindi lahat ng nasa management is nag-work sa company. Pwede silang stock or non-stock, or pwede silang shares of stock lang, or investors lang. So, in the list 5 for individuals, hindi rin sila necessarily nagre-report sa board of members. Meron siyang designated people na nagre-report. Okay? Kaya when you say designated governing boards, so meron kasi silang it is called by the name. Okay? Meron silang pinaka-designated name talaga. For example, Board of Regents, Board of Governors, and Board of Directors. Sila yung madalas na nagde-decide or nagde-designated. Okay. Section 175, collection of registrations, incorporations, or other fees. Ito yung kino-collect ni SEC. It is fees, charges, and compensation or compensate, and fine. Ito yung kino-collect ni SEC every year. Yun. And then, syempre, wala naman ng libre ngayon. Lahat may bayad na. So, ganon. Pero, limited capacity ng capital. Syempre, hindi naman if ever na ganito yung capital na inano ni SEC. Si SEC ang nagde-decide kung magkano ang ibabayad mo based on their computation or analysis. So, kapag si SEC is nag-collect na ng mga fees, charges, or compensation, it should be separate account in some, like employees' wages, yung mga ganyan, na hindi naman required sa requirement ni SEC. Okay? Next is the Section 176, stock ownership of corporation. So, it means the NEDA, the National Economic Development Authority. So, in this, it is based on the stock ownership. So, it means na it can be limited public interest siya. Dati kasi daw, based on some
survey lang na dati unlimited siya. Ngayon, it is limited public interest na lang siya based on na it is open by public. For example, Jollibee, yan. Like Meralco, yan, mga ganyan. So, limited na lang siya. And sometimes it depends on the stock ownership of affinity, kamag-anak, kapamilya, kadugo, and then, yun nga. So, it defines to the corporations. It should had an analysis nga or geographic environment. So, meron pa silang tinatawag na commissions of competitives para for yon, for the company yon, for the environment, it is para sa socio-economic yon. So, yung NEDA yung nag-aano nun about the corporations. So, the last one is the section 177. The last one is the reportorial requirements of the corporation. So, dito pumapasok lahat ng requirements ng SEC. So, they require the General Information Sheet or the GIS, the Annual Financial Statement. Annual Financial Statement is mga certified public accountant ang nag-handle nito. Sa General Information Sheet, ang pagkakaalam ko is the detail of sale. Ayan. And then yung mga board of trustees, yan, yung mga ganyan. So ang sa SEC kasi, yung mga requirements na pinapasa nila, like, in a fiscal year, every corporation has to pass their requirements. Kasi, syempre, nire-revise yan ng SEC. And then, not all the time is pare-parehas sila ng year na ipapasa. Not all the corporation is pare-parehas. Diba? Based on the SEC, based yan kung kailan na-establish ng SEC. Okay? It is fiscal year yon. So, sometimes, merong mga corporation na i-establish by October. So, magpapasa sila ng another requirements in the next in the fiscal year of by October. So, not all the time kasi ng corporation is nag-i-start sa January, diba? So, that's all po. Thank you.
So, good day everyone. I am Noriel A. Fabrigaras and I'm going to discuss Section 178 to Section 182 of the Title 17 Miscellaneous Provision under Republic Act 11232 or the Revised Corporation Code. So, Section 178, Visitorial Power and Confidential Nature of Examination Results. The Commission shall exercise visitorial powers over all corporations, which powers shall include the examination and inspection of records, regulation and supervision of activities, enforcement of compliance, and imposition of sanctions in accordance with this code. Should the corporation without justifiable cause refuse or obstruct the Commission's exercise of its visitorial power, the Commission may revoke its certificate of incorporation. This is without prejudice to the imposition of other penalties and sanctions under this code. All interrogatories propounded by the Commission and the answers thereto, as well as the results of any examination made by the Commission or by any other official authorized by the government or by law to make an examination of the operations, books, and records of any corporation shall be kept strictly confidential, except when the law requires the same to be made public, when necessary for the Commission to take action or to protect the public or to issue orders in the exercise of its power under this code, or where such interrogatories and answers or results are necessary to be presented as evidence before any court. So basically, Section 178 in Title 17 Miscellaneous Provision talks about the power of the state through the proper government agencies to examine business affairs, administration, and conditions of the corporation. So this means na hindi lang yung SEC or yung Security and Exchange Commission ang may visitorial power. Other governmental agencies also have visitorial powers, such as yung SEC, BIR, Insurance Commission, Bangko Sentral, NTC, DOLE, and COA. So, dapat lang natin tandaan sa visitorial powers are una yung kanyang nature. A visitorial power is a public right. Pangalawa, yung purpose of visitation, that is to supervise and control the management of corporation and also to keep them within the limit of their power. So next is yung scope ng visitation. Yung scope niya is any corporation inside the Philippines. So obviously it can apply to special corporations or those which have special charters, and also to foreign corporations. Next is the revocation of the incorporation. So this is also under Section 178. So if there's a refusal or there is an obstruction of the exercise of the SEC of its visitorial power, this is without prejudice to other imposable penalties under Revised Corporation Code. Also, please take note that all interrogatories are confidential, and yung answer which are given to the interrogatories by the corporation are confidential unless if it is in public interest. So, exception to confidentiality rule is una, when otherwise provided by law. Second, to protect the public interest. And last is they will be presented as evidence in court. Next is Section 179. So the power of the Commission or the Security and Exchange Commission are enumerated in this section. Power, functions, and jurisdiction of the commissions. The commission shall have the power and authority to, actually marami to sila, this is from letters A to P. So I will not discuss it any longer kasi it is self-explanatory naman na. So una, the commission shall exercise supervision and jurisdiction over all corporations and persons acting on their behalf, except as otherwise provided under this code. B. Pursuant to Presidential Decree Number 902A, retain jurisdiction over pending cases involving intra-corporate disputes submitted for final resolution. The Commission shall retain jurisdiction over pending suspension of the payment or rehabilitation cases filed as of June 30, 2000 until finally disposed. C. Impose sanctions for the violation of this code, its implementing rules and orders of the Commission. D. Promote corporate governance and the protection of minority investors through, among others, the issuance of rules and regulations consistent with international best practices. E. Issue opinions to clarify the application of laws, rules, and regulations. F. Issue cease and desist orders ex parte to prevent imminent fraud or injury to the public. G. Hold corporation in direct and indirect contempt. H. Issue a sub pena duces tecum and summon witnesses to appear in proceeding before the Commission. I. In appropriate cases, order the examination, search and seizure of documents, papers, files, and records and books of accounts of any entity or person under investigation as may be necessary for the proper disposition of the cases, subject to the provisions of existing law. J. Suspend or revoke the certificate of incorporation after proper notice and hearing. The Commission also has the right to dissolve or impose sanctions on corporations upon final court order for committing, aiding in the commission of or any manner furthering securities violations, smuggling, tax evasions, money laundering, graft and corrupt practices, or other fraudulent or illegal acts. L. The Commission can issue writs of execution and attachment to enforce payments of fees, administrative fines, and other dues collectible under this code. Letter M. Prescribe the number of independent directors and the minimum criteria in determining the independence of a director. N is to impose or recommend new modes by which a stockholder, members, directors, or trustee may attend meetings or cast their votes as technology may allow, taking into account the company's scale, number of shareholders or members, structures, and other factors consistent with the basic rights of corporate suffrage. Letter O. The Commission can formulate and enforce standard, guidelines, policies, rules, and regulations to carry out the provisions of this code. And lastly, it can exercise such other powers provided by law or those which may be necessary or incidental to carrying out the powers expressly granted to the commissions. So in imposing penalties and additional monitoring and supervision requirements, the commission shall take into consideration yung size, nature of the business, and the capacity of the corporation. No court below the Court of Appeals shall have jurisdiction to issue a restraining order, preliminary injunctions, or preliminary mandatory injunctions in any case, disputes, or controversy that directly or indirectly interferes with the exercise of the power, duties, and responsibilities of the Commission that falls exclusively within its jurisdiction. So ano ibig sabihin nito? The Court of Appeals and only the Court of Appeals can stop the action ng Commission or ng SEC. So, if you guys want to stop the actions ng SEC, punta lang kayo sa COA or the Court of Appeals, and the Court of Appeals will issue a restraining order, preliminary injunctions, or preliminary mandatory injunctions. Okay, so next is Section 180, the development and implementation of electronic filing and monitoring system. The Commission shall develop and implement an electronic filing and monitoring system. The Commission shall promulgate rules to facilitate and expedite, among others, corporate name reservation and registration, incorporation, submission of reports, notices, and documents required under this code, and sharing of pertinent information with other government agencies. So actually, nasimulan nila ito, yung electronic filing and monitoring system, pero according sa iba, naging palpak yung implementation ng electronic filing kasi sobrang bagal daw ang kailangan sa madaling araw pa mag-filing and dapat Chrome pa ang gagamitin. So sabi it is a complete nightmare and mas maganda daw yung manual filing lang. So let's proceed to Section 181. Section 181 states that the arbitration for corporation, an arbitration agreement may be provided in the articles of incorporation or bylaws of an unenlisted corporation. When such an agreement is in place, disputes between the corporation, its stockholders or members, which arise from the implementation of the articles of incorporation or bylaws, or from intra-corporate relations, shall be referred to arbitration. A dispute shall be non-arbitratable when it involves criminal offenses and interest of third parties. So, una nakalagay mismo sa articles of incorporation na may arbitration agreement. So, kung mayroong intra-corporate dispute, i-arbitrate muna. So, pag-uusapan, then may isang arbitrator and that arbitrator will decide. Okay. So, the arbitration agreement shall be binding on the corporation, its directors, trustees, officers, and executives or managers. To be enforceable, the arbitration agreement should indicate the number of arbitrators and the procedures for their appointment. So yun nga, subject matter will cover only disputes between the corporation, stockholders, or members. So the dispute will happen because of the implementation of the articles or bylaws from Intract Corporate Relations. So this means na sila-sila lang yung tawag dito, the corporation, stockholders, or members, wala silang kalaban na third person. Okay. Under Section 180 or 181 rather, states that the arbitral tribunal shall have the power to rule on its own jurisdiction and on questions relating to the validity of the arbitration agreement. So, ibig sabihin nito, yung arbitral tribunal has its own jurisdiction, meaning it can determine whether it is or not qualified to arbitrate yung disputes. When an intra-corporate dispute is filed with a regional trial court, the court shall dismiss the case before the termination of the pre-trial conference if it determines that an arbitration agreement is written on the corporation's articles of incorporation, bylaws, or in a separate agreement. So pag may arbitration or pag may isang party na nag-apply or nag-file sa regional trial court provided na may arbitration agreement silang napagkasunduan, yung regional trial court will dismiss the case before the termination of the pre-trial conference. So the arbitral tribunal shall have the power to grant interim measures necessary to ensure enforcement of the award, prevent a miscarriage of justice, or otherwise protect the right of the parties. So, kumbaga, in the meantime, habang ina-arbitrate pa, or habang pending pa yung case, or yung disputes, pwede yung arbitral tribunal pwede siyang mag-issue ng orders to prevent damages. Like, bawal munang ibenta yung stocks and etc. etc. The final arbitral award under this section shall be executory and after the lapse of 15 days from receipt thereof by the parties and shall be stayed only by the filing of a bond or the issuance of the appellate court of an injunctive writ. So additional information, if involves criminal offenses, it is not arbitrable. Okay, so next is Section 182, Jurisdiction over Party List Organizations. The power, authorities, and responsibilities of the Commission involving party list organizations are transferred to the Commission on Election. So sa madaling sabi, yung party list organizations ay hindi na hawak ng Commission. Yung party list organizations ay hawak na ng Commission on Election. So for this purpose, the COMELEC, in accordance with the Commission, shall promulgate the corresponding implementing rules for the transfer of jurisdiction over the above-mentioned corporations. That's all.
I am J.C. Emmanuel de la Cruz, the last reporter from our group, and I am going to tackle about the section 183 to 188. Section 183, the applicability of the code. Okay? Nothing in this act shall be constructed as amending existing provisions of special laws governing the registration, regulation, monitoring, and supervision of special corporations, such as the bank, non-bank financial institutions, and insurance companies. Okay? Notwithstanding any provisions to the contrary, regulators such as the Bangko Sentral ng Pilipinas and the Insurance Commission shall exercise primary authority over special corporations such as the bank, non-bank financial institution, and insurance companies under their supervision and regulation. Okay? Take note that the regulators such as the Bangko Sentral ng Pilipinas and the Insurance Commission shall exercise primary authority over special corporations such as the bank, non-bank financial institution, and insurance companies under their supervision and regulation. Next is the effect of amendment or repeal of this code or the dissolution of a corporation. Okay, this section is actually a limitations on legislative power to amend or repeal. Okay. No right or remedy in favor or against any corporation, its stockholders, members, directors, trustees, or officers, nor any liability incurred in any such corporation, stockholders, members, directors, trustees, or officer shall be removed or impaired, either way by the subsequent dissolution of said corporation or by any subsequent amendment or repeal of this code or any part of it. Okay? Dahil nga vested na ang right o nabigay na sa kanila yung right na yun, hindi ito basta-basta nababawi. At yung vested right na yun ay nagsusurvive even after dissolution. Okay, for example, your corporation is a educational institution and the charter or the school year charter or the corporate existence is tapos na. Okay? Tapos na habang sa kaligtaan ng school year. Yung vested right ng isang estudyante ay tapusin ang isang buong school year niyan kahit tapos na kahit dissolution na yung isang corporation. Okay? Ayun yung vested right ng estudyante. Basta prior sa dissolution ang enrollment. Okay? Ibig sabihin, after ng school year na to, sa susunod na school year, ay hindi na pwede mag-enroll kasi wala nang vested right. Wala nang right na magpatakbo ang school o tumanggap ng estudyante ang school kasi nga tapos na, nasa dissolution na. Natapos na ang kanilang charter or the corporate existence. Next is Section 185, the applicability to existing corporations. A corporation lawfully existing and doing business in the Philippines affected by the new requirements of the code shall be given a period of not more than 2 years from the effectivity of this act within which to comply. Okay? Take note that the revised corporation code will apply to all lawfully existing corporations and foreign corporations that are already licensed. Next is Section 186, the severability clause. If any provision of this act is declared invalid or unconstitutional, the other provisions of which are not affected thereby shall continue to be in full force and effect. Okay? Kahit anong provisions na na-declared na invalid or unconstitutional, ay hindi maapektuhan nito yung ibang provisions. And this provision shall continue to be in full force and effect. Next is Section 187, Repealing Clause. Batas Pambansa Bilang 68 or otherwise known as the Corporation Code of the Philippines is hereby repealed or napalitan. Okay? Binago. Any law, presidential decree or issuance, executive order, letter of instruction, administrative order, rule or regulation, contrary or inconsistent with any provision of this act is hereby repealed or modified accordingly. And lastly is the Section 188 or the effectivity. This act shall take effect upon the completion of its publication in the Official Gazette or in at least 2 newspapers of general circulation. Take note that the Revised Corporation Code became effective in February 23, 2019. And that's all. Thank you.
Head in the clouds.